the way the landlord-tenant law is set up in California, it's an expedited procedure. So typically a general civil action might take 1.5 years, 2 years to resolve itself. With an eviction, it might get resolved in about 2 months. So because of that, the way the legislature has set up the law is we want to make sure that the landlords do everything exactly the way we want them to do it, because we're basically forcing people out of their homes. So on the landlord side, they pretty much strictly construe everything. So if the landlord doesn't do something right, it could basically jeopardize the whole case, and they lose, and they would have to start all over again.
And they can be done in 2 months?
They can be done in 2 months. Typically right now it's running, if the tenant does not respond to the eviction lawsuit, it'll probably take about 1.5 months. If they do respond, it'll probably be about 2 months, a little bit over 2 months, because we would have to go to trial.
Wow, that's surprisingly fast.
Very fast. And the reason why it goes so fast is the landlord files their complaint. The tenant cannot file a cross complaint. The only thing that the landlord can get in an unlawful detainer action is basically unpaid rent, attorney's fees, if there's an attorney's fees clause, and costs. That's it. There's nothing else. So they narrow the issues, they narrow what you can collect, and they restrict the other side from filing a cross complaint. So they do all that to expedite it, because the legislature wants to set up a procedure where the landlord can get their place back in a fairly reasonable amount of time, because they know the landlord's paying the mortgage, the property tax, etc., and at the same time they're not receiving any rents.